The exact procedure through which expert evidence is adduced and tested in an arbitration will of course depend on the lex arbitrae, the applicable arbitral rules and the decisions of the parties and tribunal. Some general observations can however be made. References to procedure can be found in the arbitral law of many jurisdictions, albeit these do not tend to go into as much detail as arbitral rules. An example of this can be found in Article 26.2 of the UNCITRAL Model Law, which requires tribunal-appointed experts who have provided an expert report to attend the hearing and be cross-examined if either party or the tribunal requests.
The model law seeks to balance between, on the one hand, party autonomy in selecting arbitrators, and, on the other hand, the fundamental principles of fairness and justice, as well as the urgency in establishing an arbitral tribunal. Accordingly, its provisions concerning arbitrator appointment begin by applying the parties' agreement.
And so as we look at these individually, what we ask you to consider is this. The obligations on these different folks will vary, right? A fact witness is very much allied with the party to provide a detailed account of what happened. The party-appointed expert and the tribunal-appointed expert in this regard, allied in the same way together, their duty to the tribunal, regardless of how they were appointed. And that's an important thing to note. The IBA rules in general allow for appointment of both party-appointed and tribunal-appointed experts. Admittedly, tribunal-appointed experts, there is less use of this in international arbitration, but just to offer an opposite, the Prague rules, for example, suggest that the default would actually be that the tribunal appoints its expert, taking that inquisitorial and active role again with the introduction of the Prague rules. So just some things to consider as we walk through these three elements.